Yeah, but wouldn't withholding be appropriate to the extent of the repair? Where would it be appropriate that all of the amounts would be withheld? Why hasn't your client initiated the testing? If you showed the court something that said that it shouldn't be drank or that it can't be drank, that would be one thing. But that's not what I have. How much you would be owed? If the court were to come back and say, can't withhold anything, Lawns LLC.
Good morning, Your Honor. Dan Troika on behalf of the plaintiff, D Squared Partnership.
Good morning, Your Honor. Travis Gagne on behalf of defendant Eagle Lawns.
Your motion.
Your Honor, this is a date and time set for our motion for entry of a possession judgment. Your Honor, to C8C10 motion. This case involves commercial property on Morgan Road. It's in that triangle between 2394 and Michigan, where the new Amazon place is, just north of the Sam's Club. Commercial lease. It uses a standard form from Colliers. Your Honor is probably aware that Colliers essentially has cornered the commercial real estate market. So it's a normal lease, one that I work with a lot, one that Your Honor has seen, nothing unusual about it. The lease was entered into in January 2022. It's a 5-year lease. Is for an area of 3.2 acres, and there are a couple of structures on it. The tenant, runs a lawn and snow removal company out of the premises. What's not disputed is the tenant has not paid rent since May of 2025. So we're almost up on a year. The total amount due as of today, not including April, is $113,825.92. We've supported that number with affidavit. There's no dispute that it's computed incorrectly. I think if Your Honor agrees with our interpretation of the lease, then Your Honor would be, we would say, required to enter the possession judgment we're asking. So the question is, do they have an excuse under the lease, under the law, for not paying rent? If you look at the answer to the complaint, the tenant cited the residential statute, the one that allows you to pay money into a designated escrowee. This is not residential. This is commercial, so that's completely not relevant. The tenant says there were issues with maintenance. I'm going to go through those issues, but before we get to that, I think that Your Honor needs to know what the lease actually says. So remember, $113,000 is owed unless they can establish a defense. The first issue is that the lease actually anticipates and deals with a tenant withholding rent based on alleged maintenance issues. That risk is the issue. The risk associated with that is placed on the tenant. If you are a tenant and you believe under this lease form that there's an issue with maintenance, your remedy is not to withhold rent. You can file suit. You can sue for money damages. You can go to court, seek a declaratory judgment. You can't just withhold rent. And this is a very important provision of the lease because it's intended to prevent tenants from gaming the lease, which we contend is currently happening. We are without any income from this property for...
Why would you have the provision regarding the HVAC unit that were sort of an absolute about withholding rent?
So are you referring to the provision that if it's over $500, well, you still can't withhold rent. So it's an obligation of the landlord. It's a monetary obligation. We're not disputing you can sue to enforce it, but the lease has to be interpreted as written, and it says you can't just withhold rent. But I will get to that because, Your Honor, there's actually no evidence of an HVAC problem. So even if Your Honor were to interpret the lease as permitting withholding of rent as a remedy, they still haven't actually demonstrated there's grounds for withholding. But our position is the lease has to be interpreted exactly as written. It says you can't withhold. That's an enforceable clause of a commercial lease. This is not a residential lease. So that's the first issue. Your Honor, separate and apart from the withholding provision, the lease allocates maintenance, and this is a triple net lease. So generally speaking, if there's maintenance or repairs, it has to be done by the tenant. And this type of lease deliberately puts those obligations on the tenant, and the rent is correspondingly less. If this were what is called a gross rent, a gross lease, which is where the landlord is covering these things, then it would be a higher rent. So they got a rental amount that is on the assumption that they take care of maintenance and repair obligations. So under the tenant's theory, in order to withhold rent, if you accept that as an option for a tenant, they would still have to show that the maintenance issues they point to are the landlord's responsibility and not the tenant's. And they have not done that. The lease very specifically says in paragraph 10.1, the tenant will, at its own cost and expense, keep and maintain all parts of the leased premises in good condition. It says a lot more than that, but that's the important part. For your honor, it also says in 10.4 that the tenant will, at its own cost and expense, enter into a regularly scheduled preventative maintenance service contract. They haven't done that, but that's on the tenant because it's the tenant's obligation to take care of the premises. And finally, in section 6.0, there's a provision that the tenant, upon moving in, has 30 days to object to the condition. And if they don't, they will be deemed irrevocably to have accepted the condition. They also didn't provide that notice. So all those provisions clearly allocate the issue of maintenance onto the tenant. But if you get into the weeds, into the actual specific issues that the tenant has identified, that the tenant alleges justifying non-payment of rent for coming out 11 months now, they don't actually add up. There's nothing they've identified that is supported by any competent evidence that shows that the landlord, in this case, my client, failed in their duties to whatever duties they are to maintain the property. Your Honor pointed out with the HVAC. So the HVAC provision, and that was a negotiated provision, it says that in that particular case, if the repair is over $500, then the landlord will do it. So we don't dispute that, but there's nothing in the response we received from the tenant and nothing we've seen in all the correspondence we've had with the tenant that actually shows that there's a problem in excess of $500 that would make it a landlord issue. Now, Your Honor, we did provide you with an invoice from what happened in December. And in December, we were told that the heat was out. And this was during a deep freeze, might have been a polar vortex, whatever it was. This is when I first got involved, and it was an emergency. So we did send a contractor out there, and the contractor said, well, the thermostat is all the way down. And for another furnace, the pilot light was out. For two furnaces, the pilot lights were out. There was another where a wire was loose. The contractor said it was pulled, but we don't know. So we had the contractor turn everything back on. Your Honor might recall in our first hearing in January, we asked for and received from Your Honor a provision that the temperature be maintained at 50 degrees in the premises. And while there's been some questionable situations, we haven't had a repeat of the problem of the furnace turning off since we were here in January. So when our contractor went in December and did the work that we paid them for, even though it was under $500, we haven't had an issue since. So if the tenant wants to say there's work requiring the landlord to come in that's in excess of $500, they haven't identified it. Supposing there were an issue, we would do it. We already have done everything that actually needed to be done that was our responsibility, but nowhere in the tenant's response is there any evidence that shows that there's a current existing problem with the furnace. All there is a statement that it went out. Everything was turned off. We don't know how it got turned off. We turned it back on. As soon as we got an order from Your Honor, there hasn't been a problem since. So that's not a basis for withholding 6 figures of rent, which is what they're doing. There's no problem since March. We went through in some detail the response that we received last week, and it leads with the MIOSHA report that's from April of 2022. So this is presented to Your Honor as a basis for not paying rent to the landlord for the last 10 or 11 months. And look at the report. I mean, we went through every single bit of it. It says, for example, that there wasn't adequate PPE, personal protective equipment. That's not us. That's an employer issue, and the employer in this case is Ecolons. The MIOSHA report from 2022 talks about there not being a written hazard communication policy. That's them. That's not us. It says you need an energy control procedure. Everything in this MIOSHA report is geared toward the employer, which is Ecolons. And that's what MIOSHA does. They aren't actually a property inspection facility. They are looking at landlord obligation or at employer obligations. They mentioned, for example, that the string trimmers that they use for weed whacking don't have the proper shield. The one thing they commented that we actually did take care of was ground fault circuit interrupter. That's just, you might know that modern plugs have something to protect against short circuiting. While we was
so modern, they've been around. But go ahead.
Well, this is an old building. And we actually, in our reply, we did show Your Honor that we sent in an electrician who dealt with that issue. Now, we would argue that it was the tenant's responsibility, but we took care of it. We don't want the place burning down. And that's been consistent throughout this whole situation. My client has done things that needed to be done. If the tenant's not going to do them in order to protect the building, that includes the furnace. So the motion report is 4 years old. There's nothing in there that points to the landlord having failed in an obligation. And also, it's 4 years ago. So there's nothing to say that any of these issues persist to the present. The second thing that they point to justify withholding rent for the last 10 months is a lack of potable water. And if you read the affidavit, it says there was a sign from the prior tenant that said don't drink the water, which is true. There was a sign from the prior tenant saying don't drink the water. They knew that. That sign was there when they occupied the premises, when they inspected the premises prior to the lease. We actually did go get the water tested by the county, and the county came back and said it's actually okay. Would I drink it? No, probably not. It's a brownfield, it's a well. But there's nothing in that condition that the tenant did not know, and the tenant was deemed to have accepted that condition because he didn't object within 30 days. But that's really...
Drink well water? Drink well water?
Well, this is a brownfield. I mean, this whole area is very industrial. So, I would be paranoid. But I will say my client actually did talk to the county about it, and we believe that water is safer than the water we would get from the township. But I wouldn't drink that either. But at the end of the day, this is not a basis.
Bowles at Pittsfield Township, all in one sentence.
Yep.
Okay, go ahead.
So there's no basis under the lease for withholding rent due to the alleged lack of potable water. If there were an issue, they irrevocably conceded it because it did not object within 30 days. The next thing they raised, for Your Honor, is the furnaces, which we've talked about that.
Just so that I'm clear on the water situation, it really is. The sign that was there was more of a preference than it was a mandate.
Nobody, to our knowledge, has ever mandated that the water not be drunk. This is an industrial area.
Right.
It is a well. So we would not advise the tenant or anybody to drink it. It's perfectly useful for whatever your business needs are. But drinking, yeah, I would take bottled water, but this is not a secret. The tenant was aware of this issue when they moved in, and they had 30 days to object. I don't know what we could have done about it because the well is what it is. And we did do the one thing we could do, which is go to the county, and the county said it passes. So they haven't provided any evidence that it's not drinkable. But even if, in an abundance of caution, you shouldn't drink it, that's not a basis for not paying rent. And there's nothing in the lease that says otherwise.
Was that sign placed, as best you know, from the prior tenant?
Yes. Yeah, the prior tenant put it there. And it was there when the current tenant moved in.
Okay.
We then got from the tenant and in the response brief a maintenance checklist showing the maintenance that they say they've done since they've been in the premises starting in February or January 2022. And you can take a look at it. It says things like we had to go clean the sump pump, and we did pest controls, and we checked the fire extinguishers, and we checked the furnace, and and it also says at one point there was a landlord notice because there was excessive debris outside. We checked the air compressor. We checked the pilot lights. That's what the checklist says. Those are all things they have to be doing. Those are requirements of the tenant under a triple net lease. So none of those are things that were our failure. They're all things the landlord, the tenant needed to be doing. And we assume they did them. We don't know. But my point is that list that was given to Your Honor is not an excuse for not paying rent. They then presented in their response a formal demand from April 9th, 2025. And that's also part of what they put forward as evidence that we're not maintaining the water. So they mentioned potable water. Okay, we've talked about that. They mentioned electrical panels. On that point, we sent an electrician in. Now, this was earlier in the lease in 2022 when they first gave us the MIOSHA report, that's when we sent electrician in. We said deal with the GFCI issue, the grounding. Also make sure the electrical panel is in order. All that stuff was done. There is no evidence from the tenant that there's any electrical problem as we speak today. So there's no basis for withholding rent. And I want to remind your honor, this tenant's withholding all rent. So, we don't believe this lease allows it, but if it did, it doesn't allow withholding everything. But again, there's nothing in the response from the tenant that shows that there's any current electrical issue. The issues that did exist with the grounding, we took care of. So this list from April 2025, it also complains that the toilet's not working. It says that the sink in the bathroom is leaking. It claims the water heater leaking. And it says that the shop bay doors were not sealed well enough. I mean, these are all things that plainly fall under the maintenance obligation of the tenant. They're also very small things. I mean, each of these things are easy to fix. But my client, when they entered into this lease, did not agree to come and fix the toilet. That's on the tenant. And all these triple net leases expect the tenant to take care of that routine maintenance. So that demand from April 2025 does not identify any existing condition that it's my client's responsibility to address. And there's no evidence to support it. No expert testimony, no nothing. This is, in our opinion, just blowing smoke. This is a tenant who doesn't want to pay and is throwing out these things to try to get your honor to go along with that strategy. But when you look at each item, like the water, the electrical panels, the toilet not flushing, these aren't our responsibility, or they were accepted. There are some other issues that have come up in the response, which we did address preemptively in our motion. I don't know how much your honor wants to get into it. We showed in our original motion that the tenant did come to us and asked us to take over the maintenance obligations. He gave us a proposed amended lease that would shift maintenance from the tenant to us, and we didn't sign it. So you can't hold us to a lease that we didn't sign. The reality is, tenant signed a triple net lease, and we never agreed to take on those maintenance obligations, and we would not agree to, because that's not what we do. Tenants also complain about the billboard. They've made an argument in their response brief that we have deprived them of the use of the property because we're not letting him sell billboard space to a third party. Your Honor, I have cited in our briefs that the landlord has the right to decide sign usage, and they asked us to enter into a 10-year lease that would give the tenant the right to lease the billboard to third parties. We didn't want to do that. It's an unreasonable ask, and it would exceed the limit of the lease. So there's no requirement that we enter into a 10-year business deal with a tenant, and we chose not to. If your honor is going to consider those things, we would respectfully ask that it actually go into the court's order, because then it would be issue preclusion when we're in circuit court. And of course, I leave that to your honor. We don't think your honor should get to any of that, because this case should be decided by the anti-withholding clause. But if we do get into lease, we're not under any obligation to sign a proposed 10-year lease, and we chose not to. They've complained that my client, on the advice of counsel, entered the building in early December, to turn the heat back on. I will tell you, I did advise my client, I would never tell a client to sit back and let your property get destroyed. And we did it the right way. Called the police, had the police escort us, went out there and had things turned back on. But supposing we shouldn't have done that, that's not a basis for withholding rent starting in May of 2025. It's just not a basis for withholding rent at all. But I would submit to your honor, the whole idea that we can go and protect our building is not something I would ask your court to endorse. That would mean my client has to sit back and let the building essentially, suffer a catastrophic loss. There was a suggestion that violates the anti-lockout statute. Your honor, anti-lockout requires locking out. The tenant is still there running its business. There's been no lockout. We're here asking your honor for an order, and if your honor grants that order, then we'll have a basis for locking the tenant out. But to date, we haven't done it. There's a citation in the brief to a provision of the Summary Proceedings Act that talks about the possibility of adjudicating a breach by a landlord that, quote, excuses the payment of rent if possession is claimed for non-payment of rent. Well, in this case, the alleged maintenance issues don't excuse the payment of rent. The lease is clear that you can't withhold. But even if Your Honor felt that a tenant could withhold, there's nothing they presented that's a maintenance issue that's the responsibility of the landlord. They just haven't done, they haven't shown it. So we're looking at a situation where the defendant, Ecolawns, has demanded a jury trial. And so if Your Honor denies this motion today, presumably we're going to have a jury trial. And I don't even know where to begin with what a jury is going to be instructed on, what the argument is going to be, because they haven't identified anything, any maintenance issue that is our responsibility. Again, it's a triple net lease. If you're going to come in and say the tenant has, the landlord has not complied with his maintenance obligations, then you're going to have to do something to support that. There's going to have to be something to explain why it's our obligation and not theirs. There's going to need to be something from a competent expert or at least contractor backing up the claim that things aren't working. I think the HVAC, probably since Your Honor mentioned that, is the best illustration. We do acknowledge if there's a problem over $500, the lease says that's our responsibility. And if there is, we would take care of it. We don't want that property to freeze. So if the furnace broke and no longer worked, we would pay whatever it costs to fix that problem because we don't want pipes freezing. I mean, and they have not identified anything. The only thing they identified was that on a certain day in December, all of the furnaces were out. And we sent somebody there and he turned all of them on. And we haven't had an issue since. So that's not evidence that there's an existing problem justifying the withholding of rent. But if there were, we would take care of that problem because we don't want the property to be damaged. That matters probably more to us than it does to the tenant.
You would agree that if, for example, if I just took the electrical panel, there were significant problems with the electrical panel that fundamentally would make the building useless. But at the time that they moved in, it was okay, but something has happened in that interim period. That might be a justification for a tenant withholding rent despite the language.
Your Honor, I think if it
To the extent of the repair.
if it rises to the level of constructive eviction, then I would agree with Your Honor. But this is not constructive eviction. Another example would be, let's say there was a fire, not the tenant's fault, and the place no longer can be used. Sure, they would be entitled to an abatement to terminate the lease, what have you. But what they can't do is say, oh, I don't want to drink bottled water, I want to drink from the faucet, and because there was a sign when we moved here, we're not going to pay you ever again. I mean, bear in mind that what they've said they want to go to a jury trial because they think there are fact issues. But their position is that if we went to a jury trial and it was established that you shouldn't drink the water, that they'll never have to pay rent again. I mean, they're asking Your Honor to endorse that. So while I would acknowledge there is a category theoretically of constructive eviction, which would be a different analysis, in this case, everything they've said is the tenant's responsibility, or it's just trivial, and there's no evidence to support it. The furnaces are fine. The water is fine for all purposes. Yeah, again, we would drink bottled water if it was us, although the county says you can drink it, it's safe. And everything else is just in that category. The toilet, that's their job to fix it. I've looked through all this. I have no clue what I would say to a jury, given what they've said. They have the burden on showing that there's a problem with the property so severe to justify non-payment of rent, and they haven't come close. So this has gone on now for 10 months, about to be 11 months. We do think enough is enough. They haven't met their burden for withholding rent, assuming it's permissible under any circumstances, and we ask Your Honor to enter a judgment for possession today, which they would have the right to pay. For the record, I want to be clear. The tenant has paid $28,050 into escrow. We are asking the court to enter a judgment for possession and also in order releasing the escrow, and we would of course credit the $28,000 against the amount owed. So then the tenant would have to pay $85,775 on top of the escrow to retain possession within 10 days. And if not, we will evict them. And the tenant has known this was coming for many, many months. Your Honor should know this is not the first non-payment. We had to serve a notice of non-payment of rent back in April 2025, a year ago. At that point, they did pay, they caught up, and then they quit paying again in June. My clients were represented by Mr. Lloyd at the time, and he wasn't able to continue representing them. So there was a bit of a lull until I got involved. So we asked Your Honor, enter an order, judgment of possession, required payment of $113,000 in change is set out in our motion, and they'll have 10 days to pay and release to escrow, and we'll credit that. And Donna, do you have any questions or anything?
No.
Thank you.
No. Mr. Gunner.
Good afternoon, Your Honor. I'm going to try to be as concise as I possibly can. We just heard a lot about different issues that were raised, whether through a demand letter in April, through the response to the brief, throughout this litigation. What you didn't hear is, oh yeah, we fixed that. What you heard was, not our problem. You heard a lot of selective examples, whether it's in the contract or whether in the timeline. For instance, the HVAC system is a major issue that has been cited over and over by my client. You've only heard about an instance in December of 2025, but that was after the withholding had started, after this had already been cited as an issue.
Client called somebody in to get an inspection of the HVAC?
They did, and that's what started this. In not December of 2025, but in December of 2024, which is in our response brief, a technician came in and said, this is a 30-year-old furnace that needs to be replaced. It is beyond repair. My client reached out to Mr. Bender, who owns Plaintiff, or is the principal at Plaintiff, and said, this needs to be fixed, and was told, oh, it's, a pilot light issue. There's some products that you can get at AutoZone. You can fix it. That's how this started. This started because there was a demand that was generated from a technician coming out and inspecting it and saying this unit needed to be replaced. As Plaintiff has already admitted while they were up here, repairs and maintenance over $500 are the responsibility of the landlord. As Your Honor has pointed out, there are certain things, despite reading this motion and the reply saying, well, of course, this is a triple net lease. It's all on Ecolons to figure out their own maintenance, do all of the repair. There are instances where withholding is appropriate, despite the very emphatic statements that withholding can never be appropriate. And we've cited those.
Yeah, but wouldn't withholding be appropriate to the extent of the repair? So if there were an electrical panel issue, I think that's the example I was using, and that was damaged and or somehow was faulty, deterioration, whatever, and it became unusable because of that. If the tenant came in and said, okay, $5,000 to put in a new panel, and they withheld that $5,000, that would be one thing, right? Where would it be appropriate that all of the amounts would be withheld?
The judge listens carefully as the argument over unpaid rent unfolds in court. One side claims serious issues with the property, while the other insists the tenant simply stopped paying. The judge begins pressing for real proof, not just complaints. In court, claims alone are never enough. But here's the real question. Can someone stop paying rent just because they believe something is wrong with the property?
Sure. Your Honor, it is to incentivize the actual action, repair, or effort for a multitude of things. We've just heard from, near 15, 20 minutes about all of the problems that have been cited. Potable water. Again, I don't know that it is an appropriate response for a landlord to say, just drink bottled water, which is what my client was told upon moving in. It wasn't just that it was the previous tenant sign,
Yeah,
although the previous tenant
heard about the water.
We have employees that are unable to drink water. And then under Michigan statute is a...
Hold on a second.
Sure.
Is it their preference not to drink that? Or is it that it can't be drank?
We are not convinced under the evidence in this before this court right now that it can be drunk. What we have is a report.
I don't know. That was because, the county water, they'd come out they would tell you whether or not that water is safe to drink.
Sure. The report that we received, again, just in the motion briefing, this was not something that was available to us previously. But in the motion briefing, it says that there was a water test, but the sample was obtained by the owner without knowledge or consent of the defendant. We don't know what the chain of custody was. Did he take his water sample while he was there doing other things and then send it to the county? Did the county come and take it?
What did your client do? I mean, if they're saying that we're withholding rent because the water's unsafe to drink,
Sure.
then it would seem to me that they would get the test.
Your Honor, I guess in that setting, they trusted the word of their landlord, which was don't drink the water.
Yeah, but then you're questioning the word of the landlord, because then you're saying, so there's a sign that says don't drink the water.
Sure.
Not potable water. What's the reason for that?
Don't drink the water because the water's not potable. You should drink out of bottled waters, is what they were told, again, by landlord upon moving in, and what had been held for months. The previous tenant had also told them that there were issues with the water and you could not drink it. And that previous tenant will be one of the witnesses that we claim. I just want to level set this and contextualize this for the court. We've been told a lot, there is no evidence. There's been no discovery. We've not taken any depositions. There are no witnesses before this court. This isn't an evidentiary hearing. So to the extent that this is a C10 or C8.
But what I'm trying to figure out is if the complaint, let's go back to the water. The complaint is the water. What has your client done to test that water?
We have not tested the water.
Okay. So then if they come in, see the sign that says don't drink the water, and don't object to it within 30 days, why isn't your client stuck with it?
Those issues were brought up within, and I'm not sure if it's 30 days, but they were brought up at the beginning of the lease. This has not been in 2025 now, we've just manufactured them.
I'm having a hard time with the water issue.
Sure.
Okay. How can I withhold rent saying the water is, well, let me ask this. What would you have the landlord do regarding that?
We would request, first off, a test that was done by the county water, or by the county when they came out and collected the sample, and that it be collected from multiple sources in the building, not just one source, so that we know whether the water is actually safe to drink. If it is not, then we would ask for a correction to that. That's not regular maintenance.
That's what I'm a little bit worried about. Your client, I mean, and it initially appears to the court, and I don't know that the lease necessarily benefits your client in this regard, but there are these complaints that are justifying the withholding of rent because the landlord's not taking care of it. Why hasn't your client initiated the testing? I mean, it would be a different circumstance if he said, we called the county out, they tested it, they said, this water can't be drank, it's not usable for the purposes of human consumption.
Sure.
And then you look at the landlord and say, yeah, this gets to the point where we have a problem. But that's not what I have here, right?
That's fair. I guess, Your Honor, I would say up until 2 weeks ago, we didn't know that non-potable water was a contested fact. Nobody had contested that it was non-potable water up till that point.
Okay, so here's the thing, and I kind of get that. You probably don't drink well water either, right?
Well, not where I currently live, but I've drank.
Well, I drink well water at times.
Sure.
Our pointer didn't drink it. Our dogs won't drink it. So I have to bring them bottled water, so I might as well have it myself. So, that doesn't mean that the water's not safe. It typically, quite frankly, for most people that are on wells, becomes a preference.
Sure.
Right? And I don't think a preference rises to the level where one can withhold rent. And if there's a claim that the property or that the water, that humans may not want to consume the water, and before holding rent, the tenant has to show something. And I don't have anything here other than what might be a sign put up by somebody who I don't know who put up the sign, but that might be their preference. I mean, certainly in that part of the county, part of the problem with well water is it's high content of rust. Very high content. And so it tastes funny, right? And so the question becomes whether or not it's going to hurt a human being or whether or not a human being shouldn't be drinking it as opposed to that. If you showed the court something that said that it shouldn't be drank or that it can't be drank, that would be one thing. But that's not what I have.
And I guess what I would say, Your Honor, is, and I understand the issue that you're bringing up of timing, right? That this is something that you feel should have been done prior to April of 2025. Well, not April 2025, but prior to June of 2025, because rent has been paid up through May. So it should have been done before the withholding took place. I guess what I would submit is that
it could have been done at either point. When they moved in, see the sign, get it tested, and then later on just say, okay, this is too burdensome. I don't know. Do they need to dig another well? What do they need to do?
Yeah. And I understand that, and that's unfortunately something I can't go back and change in time. What I know is that my client heard this from the landlord, has brought up these issues and concerns, was never told this is a preference versus actual safety issue, and just accepted it as this is non-potable water, which is the complaint. And up until of course, Your Honor.
Oh, that's mine. It's
you.
It's not.
Oh, wow. Okay, it's okay. Okay, I didn't know what that was. Go ahead.
So Your Honor, I hear that, and I think that is something that, again, we're up until this motion, we didn't know that it was ever contested that it was preference over safety. We thought it was always safety, and that there had never been pushback on that they were able to actually drink it. Just the first time that we're hearing of that. Now, again, in the course of discovery, or leading up to a hearing or a jury trial, we would certainly go and run our own tests or have the county come out so that there was a proper chain of custody towards that testing. And if the county or other appropriate government officials say that it is safe to drink, then we drop that. Now, I do say, there's been a lot of, well, withhold rent, then they'll never pay again. That's not what's being done here, right? There's a withholding of rent, but there has never been an argument that just no rent will ever be paid ever, right? Since the court has put in an order for escrow here, my client has been diligently paying into the escrow. We have said in our response to the motion, this isn't we will never pay the 6 months of rent that aren't in the escrow outside of that amount. It is that we're demanding certain things, and potable water is certainly something we've talked about for a while. It isn't the only issue, with the HVAC issue. Again, we had a technician that said you will continue to have interruptions and problems with the HVAC. Heat will go out. Again, it's been referenced, that there was December of 2025. We have a sworn statement in here that we have never turned off the heat. We have never blown out a pilot light. We've never unplugged anything from those HVAC units. And again, I understand the idea that a landlord says, well, we can't have damage be done to the property. Although at noon that day before, they had a contractor out there who supposedly turned everything on. And, instead of having the police come out and escort them to cut the lock and barge in without any notice to my client, what could have been done is a call to our firm, who've been representing the client for about 6 to 7 months at that point, to make sure that the client was not turning things off, or a reach out to the tenant to say, did you turn this off? Could you please make sure that you don't do that so that you don't risk damage to the property. It wasn't a unilateral, non-noticed showing up with a police officer after the close of business, 6 hours after the technician had been on site, to go in and inspect the property when no one was there. That's the kind of issue that we're dealing with. With the HVAC system, it is important that there be heat. I think that is non-contested. To your point on the electrical system, we have cited both in our affirmative defenses, but also in the response to the motion, that we have had electrical interruptions. That has been something that has been cited since April of 2025 and was cited in the demand letter. If you see from the April 2025 demand letter that went to Mr. Lloyd, the electrical systems were cited. And what you didn't hear today is, well, everything's been fixed. What you heard is there's not enough evidence. It's their burden. Well, this is a C10 motion that they moved for.
What are you claiming is the problem with the electrical?
We are claiming that the electrical panel needs substantial work because the electricity does not have a continuous service. And again, we're operating a business that requires charging of devices and lawn care systems, and we need to make sure that the electrical system isn't uninterrupted. That is something that was cited in our response to the motion as a problem that is ongoing to this day. I also want to put clarity in that the maintenance log that we submitted was not evidence for the withholding. The maintenance log is in response to a lot of allegations that my client hasn't lived up to their end of the triple net in maintaining the property. It's not to say that they, that was supposed to be on them. We know that it's on us, and we're showing that we have been fulfilling our end of the bargain. We have been maintaining the property. We've been doing regular inspections. We've been doing cleanups.
But you're saying it's something beyond regular maintenance. Where, when I get to the electrical panel, what's the problem?
As cited in the April 2025 letter to plaintiff, the building electrical panels are outdated and pose a fire risk. A licensed electrician and township code inspector must inspect the panels under the state code. And then there were pictures of the panels themselves and where
What's that from?
That's from my client to plaintiff.
Right. So if you're telling me a panel is outdated,
Sure.
or that there's some problem, or that causes a problem, then why wouldn't I get somebody from the township out to inspect the panel and say, this has got to be replaced? Then send the landlord something saying, Pittsfield Township says, this panel is no good, needs to be redone. Why didn't that happen?
And my understanding is that it wasn't an inspector that had come out, but there have been multiple technicians that have come out and cited problems with the paneling and said that it is an outdated panel that needs to be replaced. I will note that in terms of Pittsfield Township's inspections, they don't have an inspection on file for a very long time. In fact, when we've called Pittsfield Township to check in on this, they were surprised to hear that there had been a new tenant in the last several years, decade, as there hasn't been the mandatory inspection required between tenancies.
But, so, when that call was made, I don't have anybody from the township or an electrician that just says, this panel is no good.
Sure.
Okay.
At least in front of Your Honor right now. Our contention is that, of course, we would bring our electrician to testify.
Yeah, but when facing a C10 motion, I mean, you can't just say, we'll get it later, right? And Hey,
We did provide a sworn affidavit from my client. It said that this is what he's been told by those technicians.
well, that's gonna have problems on a number of levels, but go ahead.
Again, there's also an issue on constructive eviction, particularly when it comes to the sign issue, which has been brought up, and a prior breach along with the sign. And Your Honor, we're not trying to litigate what is most certainly to be a circuit court case on the sign issue. We're not trying to get into the weeds on it. But I think it is important for context here, specifically what we're complaining about, that under the lease, we were entitled to the usage of the sign, irregardless of the 10-year business plan that was going to be for third parties and to generate whatever revenues, which would be certainly a part of a different case, not before us today. I also would like to address the fact that it's been brought up in the motion. I've referenced this in the response. It's been brought up today, though, so I think it's important to highlight when it comes to the alternate leases, those should not be entered into evidence. When we presented an alternate lease, it was in the midst of this dispute as a communication from a lawyer to another lawyer to say we need to resolve the dispute. That is 408 and shouldn't be entered into evidence. And so I would ask that it be struck from the record on that basis. But as it relates to the billboard issue, we did, under the lease, have the right to use the sign. We did have prior written communications from landlord that said, you may go out and apply with MDOT and Pittsfield Township to utilize the sign fully. We did go to Pittsfield Township, who approved our usage of the sign. We also went out, and again, there was a time when Pittsfield zoning said, oh, I think we're going to challenge that. It got appealed. It has been approved. We are okay. Seemingly the last step in this was MDOT. MDOT had already had the application in. It was already signed by landlord. Landlord had already communicated privately that he was supportive of us going forward with the sign. It was only after the first time that we were bringing up issues in March of 2025, well, not first time, but the procession here, which led up to the current rent withholding that we're talking about, that landlord contacted MDOT and withdrew his approval. We got a letter from MDOT that said, you had prior been approved. We were working on the final application, but I'm sorry, we can't go forward without the permission of your landlord. And the only reason that was cited for that was we were mistaken. We didn't know that that's what we were committing to, allowing you to use the billboard. That's a deprivation of part of the property. It is on the property, it is in the lease, it is contracted for, and we were deprived of the usage of that. We cannot use that billboard as we intended from the beginning of the lease, and as was communicated to the landlord, was our basis and rationale for using that, and we're not given any reason. It's just that the landlord doesn't feel like it now. Despite prior written communication saying yes, now it's a no.
But counsel, under the terms of the lease, wouldn't that be something that would need to be, and both of you agreed that this is likely to be a matter for circuit court, but wouldn't the tenant, when I look at the whole lease, the tenant's obligation would be to continue to pay the rent and then sue for what loss he may have by virtue of an inability to use the billboard because, as you're alleging, was some result of the landlord's withdrawal of its approval or its consent. Isn't that the way that it should go?
That is I won't say that is an unreasonable remedy that tenant could have in that circumstance. The tenant in this case chose to withhold rent on a laundry list of issues. Again, not just the billboard issue, but potable water, HVAC, electrical systems, mold remediation, which was cited as well, and denying access to the billboard, which again was through the permitting process, but also because there is wiring that is not going, at a loss for words, Your Honor, I'm sorry, is not functioning properly, on which landlord admitted that he was aware of that problem, which also prevented the use and access to billboard, which is still not
The wiring to the billboard itself.
which is it's an infrastructural problem.
Again, let's say all of that's true
Sure.
with reference to the billboard. Why didn't the tenant, the client, didn't just have the repairs done? Do one of two things then. Either sue the landlord for that or say, I had this repair done. We think this belongs to you in terms of the electrical, and withhold that portion from the rent.
That could have been a route to remedying as well, Your Honor. The tenant in this case chose to withhold the rent. And again, not indefinitely, not that it would not be paid at some point, but withholding on the specific and explicit demand that when the issues are covered, he would pay rent and continue to move on. As we stand here today, and as we put in the response to the motion, he is not unwilling to pay the rent. Now, again, we have some calculation issues. I think that it is not the case, as opposing counsel has stated, that is undisputed. I think there are disputes as related to the outstanding amount. For instance, one, there's a late fee that is being assessed, which is an automatic 5% late fee per month on any outstanding rent. We do not think that is proper. Two, this is a triple net lease.
That the 5% is not proper because
we think, first off, we were properly withholding. Second off, that it's an unconscionable and it's a penalty on not paying rent. It is essentially prohibited liquidated damages. But
it's the type, but unlike with a residential lease where theoretically anyway, the late fee is to be related to the cost of collection. That's not true in commercial leases.
True.
So. All right, well, go ahead, I'm sorry.
Additionally, there is a base rent, which we do not contest. The base rent was agreed to in the lease when it was first negotiated. But the triple net amount, only the first year is written. On the express terms of the lease agreement, it says that the amount afterwards, which would include insurance, and property taxes, that was to be discussed and agreed to in writing every year. It has not been. Now, again, it's not before Your Honor that we're talking about years that we could contend that was a breach prior, but in terms of the calculated amount before Your Honor, we again, would like to see an accounting of what that amount actually adds up to. It's not appropriate to just say when a lease specifically calls for agreed to in writing. We should be able to see that and agree to it in writing, and we have not yet. Having said that and bringing up those issues, Your Honor, again, it has not been the position of my client that he is unable to or will not ever pay the rents. He is able to do so. And again, in the alternative, we are arguing that withholding was proper and that there should be an order to fix the things that were identified in our demand letter, in the answer to the complaint, and in the response to this motion. In the alternative, if Your Honor were to find that withholding shouldn't take place, we are able to pay that rent to retain possession of the lease. And again, we'll avail ourselves of other remedies, if necessary, under the contract or under statute, to pursue the fixes that we think are due or the breaches that we've alleged.
That's how much you would be owed. If the court were to come back and say, can't withhold anything, how much do you think your client would owe?
It is a hard question just because I don't have visibility into the taxes or insurance paid. So I guess my question would be that if plaintiff can provide receipt, and I think that they've said that in their reply to our response, that they could provide receipts for both of those things. If they did and showed a justification of those two things, we agreed that that is part of the rent under the lease agreement and would factor that in.
Yes, Your Honor, and we also supported the rent demand with an affidavit. We have it all right here.
So I'm happy, Your Honor, to look through that. Again, I agree that there is base rent that is owed, which is under the contract, and that's very clear, and we don't contend against that. And we would subtract the late fees from that calculation. So provided that, that information that has been requested, I'm happy to provide the court with an answer to that question.
I think that's all I have for my question. All right.
Okay. Thank you, Your Honor.
Anything else, Mr. Craig?
Ken, I just did want to address a couple of statements. There was a general statement that we never did anything. That's not true. We had a contractor there in December looking at the furnaces. He turned them on. He said they're okay. And there hasn't been a problem since. So the statement that we're letting a problem persist is not true. And my client would never leave a furnace problem unaddressed because it's in their interest to protect that building. So sure, they owe it to the tenant, but they also owe it to themselves. There was a suggestion that there's something wrong with the water. We talked a lot about it. I want to be clear. We had the county test the water and we certified in an affidavit. They haven't given us anything in the form of evidence. On the electrical stuff, we sent somebody in there and spent a decent amount of money on stuff that we don't think was our obligation to deal with the grounding and the panel. That was summer 2022. They haven't given us anything since then to show a problem. You heard Brother Counsel talk about technicians. We don't have any of that. All we have is an affidavit from the tenant that says, I spoke to some technician who's unknown, who said that the furnace has had to be replaced. Well, we've told Your Honor who our contractor is. We gave it the invoice, and there hasn't been a problem for 3 months. So we're just not, I mean, if Your Honor were to send this to trial, can you imagine how difficult it would be for me as counsel for the landlord to even prepare? Because I haven't heard anything today that's some actionable problem that we can or should go fix. With regard to the taxes and insurance, we provide that every year, and we gave the breakout in our reply, and we have the support material here. But they should have opposed that by affidavit, and they did not. There was a discussion about discovery. I mean, this case is now, it was filed December 17th. It's over 3 months. We haven't been paid since May of 2025. It's simply too late. My client's entitled to either get paid or to regain possession of the premises.
When you say the taxes and insurance are supplied each year, what did you mean by that? That they're sent to the defense?
They send I know they send a statement every year. Since we're in litigation, I don't know what they did this year, so I should be clear. We've got the breakout, and I attached it to my reply. And that, I will state these numbers have not been opposed, and honestly, they're objectively reasonable. There's no dispute that the base rent is $9,485. We have provided the documentation that the triple net taxes and insurance is $1,700 per month. That's based on property taxes, which are $17,000 a year. So that's over $1,000 a month right there. In insurance, which is $4,000 per year, and we have the support here. But we do think that if that were their issue, they should have brought it up earlier. But we can show them right now. We don't think that's the basis for sending this to a jury or prolonging this non-payment situation. Some of these things we can deal with in circuit court. If Your Honor,
Can I just say this? I would like to see the parties at least get the numbers so that it's what it is. Because if I were to grant, you're asking for a judgment for possession.
yes,
I'm presuming for writ.
yes.
I don't know how that would happen. If I grant your motion on a C10 basis,
Yes.
if I don't have the amount of damages.
Well, we gave that to Your Honor. It's in an
I understand.
it's in an affidavit.
But I also understand that while they might lose on the liability issue, the amount of damages, if I can't fix it, I can't give a judgment.
So, Your Honor, we did support it with an affidavit, which is a sworn statement. I understand
I know.
if Your Honor wants to break down, we have it right here.
Right. I'm just saying, when I asked you how much does his client believe he owes, he would realize if I were to grant the motion how much is owed. His dispute was as it regards the taxes and insurance. Now, you may disagree with whether or not that dispute should be there. I see your numbers,
Yes.
but I don't know what their numbers are or whether they agree with your numbers in the event the court were to go that way. That's all I'm saying.
Well, our position is they should have raised that through some form of competent evidence, but we do have the stuff here. I understand Your Honor's concern. I guess what I want to state is you probably heard 20 or 30 things today. So for us, it's...
No, I only heard one. No, I'm kidding.
Well, it's a moving target. So if this is what it comes down to, I mean, we've got it. We're ready for it.
I'm not saying that all of their claims are necessarily foreclosed at this point until I come and give my decision.
Yes.
I'm just saying, if I were to grant this on the basis of a C10, I would say there's no dispute as to liability.
Yes.
There might be a question as to damages. And so I'd like to see what whether there's a dispute. Because I can't get you, what I'm saying is, I can't get you to what you might think your remedy should be if I go that way. Without that, they may agree once they see it.
Do we have the real property tax records? I mean, the tax is public record. It's 16,543. You can literally get it from your phone.
I understand how it's done.
Yeah.
Here, Mr. Tricka.
Yes.
That's all I want the parties to do. See if they have said it wasn't sent to them. You said maybe this year because of this it did get sent. I don't know if everybody's looking at the same thing. They might have a dispute, they might not. Before I decide that I need to make a decision, you two gentlemen have been before my court, and I trust that the two of you can reasonably go through in terms of the number. Whether or not I end up there, it's the one thing, but I'd at least like to know where I'm coming from so that if there has to be a redemption figure, because you want a judgment that says you got 10 days, they say comes out that way, they can pay it. Let's try to get it done today. So go ahead, Mr. Gunn.
Your Honor, to that point, again, if we are trying to find clarity as to this point, and if the documents are here, again, not under an affidavit and with a specific note that we could see the documents, I'm happy to step into another room while court is in recess, but right then I can work that out.
All right.
If I may, Your Honor, take just 90 more seconds on liability. It was in our response, but I do want to outline that a breach. A breach of warranty was also alleged as to our defenses in terms of withholding. Specifically, when it comes to the HVAC, again, it's been said here there have been no issues. December 2025 was an endemic issue that we've been raising about a 30-year-old furnace that doesn't work properly. There have been other times. And we have done under our obligations, we have brought somebody out to check on it and relight furnaces and make sure that they are continually working. But that's not to say that there has not been any dips in heat or that the furnace isn't working anymore, which is a part of Exhibit C in our maintenance log, as we have continually logged that through March of 2025. This is further evidence that the HVAC isn't just working and all fine, and there was one instance in December of 2025 where the heat dipped.
But what would give you the right under the lease? Let's say they want to keep a furnace in there that's limping along.
Sorry.
All right.
Sure.
I don't know if this some furnaces, they're going to last for 40 years. Some aren't. So if I take it to its worst extreme, that what the landlord wants to do is they want to keep furnaces, I think there are two in there, and that these furnaces are going to limp along.
Sure.
Why is that a problem?
because they're limping along, maybe is more of a generous statement. If they continue to go out and we continue to have to call technicians to come in, inspect, turn them back on, you saw the invoice that was attached from December of 2025, that's $200. So is the remedy here that every other week we need to call out a technician, pay $200, and at the end of the year we've paid in $10,000 to a furnace that's limping along? How is that not their obligation under a lease over $500?
In front of me, then I might agree with you, but I don't think that's what I've got in front of me.
Exhibit C shows that we've had HVAC technicians continually coming out over the course of a year or more, and a signed affidavit.
How many times have they come out? Then I'll take
Juggle my paper.
Then I'll tell you what's happened at my house.
Are these falling? I'm sorry. Can I give this to you? This is the report for the triple net.
As I'm looking through Exhibit C right now, my client has just told me that it's been at least 10 or 11 times since that landlord was alerted to the HVAC unit in December of 2024 that somebody has had to come out and maintenance, and that's not including the time that is cited by landlord that they sent somebody out. Yes.
And the landlord made aware of when they're coming, I mean, obviously one or two times.
In the course of litigation, obviously, as the litigation has been going on, there have been several times that we've referenced, not every single time. We've continued to log this. Again, the technician coming out, that's one thing, but
So what's the technician do?
they come, they inspect the system, they relight pilots, turn the system back on. It's a faulty system. It continues to fail. Which is what we were told in December of 2024 when the technician came out and said, I'm sorry, but your system's too old and it needs to be replaced. We provided that technician's name and contact information to landlord.
They sell furnaces?
Good question.
They sell furnaces.
I am unsure as I stand here whether he himself sells furnaces or whether he can procure furnaces from a different vendor.
Because I'll tell you what, I could call a furnace guy out to my house today and he'll tell me that I need a new furnace or that I need a more efficient furnace.
Yeah.
I mean, that's going to happen. So, I'm a bit leery of somebody that says, especially if it's an older furnace, because they want to sell you something that only they are the ones that are repairing in the area, so you'll have to call them or something. I mean, all of those things are going on. So I get that, but okay. All right. I mean, I hear what you're saying, but I just don't.
You hear that?
Providing heat.
And it provides heat when it provides heat, and when it doesn't, then we have to call somebody back out. And again, to your point of testing, we have brought up with the landlord bringing somebody out privately to do an electrical evaluation, the fire detectors, etc. And what my client was told was, don't do that. That will open up a can of worms when it comes to inspections. So,
Yeah, but the way these two are getting along, why is he caring what he says about that? If he really thinks that there's a problem, he call out the inspections. Let him do the testing on it. Chips are going to fall where they may. I mean, it just seems to me that.
and I think he hears that now. So,
I'm not suggesting you're ready to do anything. I'm just suggesting that it seems to me, well, that's it. Is there anything else?
We given tenant council the backup that shows the exact amount that was paid for insurance for the year beginning. Is it calendar year 2026?
That's from when he moved in.
Oh, okay. Oh, so we have everything going back to the beginning of the lease, including what is currently used in our affidavit. So we would ask the court to enter a judgment today, and if the court wants to provide them opportunity, of course, that's Your Honor's discretion. We're happy with that. We would ask for the court to enter a ruling, so we believe we're entitled to it. And I've got it here. We could, if they want to take a moment, look at it.
Yeah, I'm gonna step off, take a recess in any event. It sounds to me like you got the documents. The numbers are going to be what the numbers are.
Yes.
I just like to know what the defense is saying.
Yes. Yeah.
Number, and maybe, oddly, you guys might agree.
As the hearing continues, the judge makes one thing clear. Without solid evidence, excuses won't stand in court. Complaints, assumptions, and claims must be backed by proof. So what do you think? Was the tenant justified in withholding the rent, or should the payment have continued no matter what? Let us know your opinion in the comments, and don't forget to like and share for more real courtroom moments.
We did not include late fees since Your Honor entered the escrow order, because those were, although we didn't get them, they were timely paid into court.
Right.
So that amount, which I do believe is disputed, is $4,353
and
28 cents. So in the proposed judgment, I submitted to Your Honor along with our motion. I did include the late fees through January of 2020. January 2026. I also included the $120.30. That was the filing fee, the motion fee, and the service fee. So we're asking for a possession judgment in the amount of $113,946.22. $113,946.22. I'm not sure how Your Honor does this, because it says in here that we're asking for an order to release escrow. I prepared a separate order for that, and of course we would give credit for the escrow, which is $28,050. So the total amount, if you agree with our numbers, after escrow will be $85,896. Again, I'm not sure if Your Honor has a preference. We've included the full amount in the proposed judgment, but it's understood that the escrow would be credited, and it says that.
Yeah.
I don't think that Mr. Troika and I have a disagreement in terms of the calculation of the numbers at this point. What I would say is that, again, given that their discovery has not started in this case, this is a C-10 before discovery has started, we could not file an affidavit or a report from the original tech who looked at the HVAC unit. He has passed before withholding was started, and this case certainly was commenced. So I don't have access to him anymore. And that we would get inspections in the course of discovery. All of this is what we're asking to move forward and allow proper proof that the withholding that we did was proper, that we believe the landlord knew and didn't take care of these issues. We know that we can prove that these were issues, and that there were legitimate amounts that should have been paid under the contract. It was a prior breach of the contract. It was a prior breach of the warranty, the warranties in the lease agreement. That said, if Your Honor were to find on liability against us, then based on these calculations, we would ask, again, for reasons stated on the record before, that late fees not be exercised. Again, this was not just a failure to pay rent altogether or an inability to pay. It was cited specifically for why this rent was being withheld. We would ask that costs and fee and those late fees not be assessed, which would put us in a total of $109,472.64, which is what we say is the triple net lease that is outstanding from June through March of this year. And then the amount outside of escrow, I think, court is currently holding, and that would be that amount is $81,623.92. Again, that's a large amount, Your Honor. We're, again, happy to pay it. We would ask for 45 to 60 days to do that and complete that in total. Obviously, continuing to pay the rent going forward at the $11,203.56 at the the first of the month as it becomes due from here on out.
just so that I'm clear, your calculation of the late fees is 5% of the outstanding balance. So it's an increasing amount each month.
Yes, and that's for to 10 months, June 2025 through January 2026, and it does not include February or March of 2026, because that was paid in escrow.
Did that percentage, it may not matter for what I'm potentially going to do, but did the 5% only include basically half then for the month of January?
It's the full amount for January. I didn't think about that, but
yeah, that the late fee may have been.
I mean, it's a small amount of money. Our position would be that it was late as of, I think, January 6th or January 11th, and therefore it is, rightly applied.
And you say it's approximately 500 per month, is thereabouts?
Yeah, the exact amount on the late fees is $544.16. That number would be higher today, but we're not seeking any late fees since the new rent kick in.
Got it. All right. With reference to the motion for summary disposition, issues is raised. There's clearly the issue that the plaintiff is seeking possession of the premises and the unpaid rent premises. The items there's also not a dispute that the rent was withheld. The question is whether or not there's a justification to withhold the rent. Under the terms of the lease, rent can't be held, which is not an uncommon thing in, quite frankly, commercial leases. But then when one looks to, and the court alluded to it in its questioning, certainly, the issues that are raised, are these issues so significant, and one can look at it as to either negate some warranty within the lease, some implicit warranty within the lease, or one can look at it in terms of constructive eviction. I think one can get to the same point should there be something there that could lead the tenant to legally withhold rent. Also, this court has consistently held that where we're dealing with items that are really fixtures to the premises or which increase the value of the premises, which may not go back to the tenant, that certainly it would be unfair and unconscionable for a tenant to say, pay for some large item that's affixed to the premises, not be able to remove it, and then say have a certain period left on his lease and then have to vacate the premises. So in those instances, this court has been consistent in allowing certain deductions from the rent for those types of things. In this case, really, fundamentally, we have the portability of the drinking water, the electrical panel, the HVC. I'm not going to be dealing with the billboard issue. I think that rightfully and may belong someplace else. But then we have the toilet, the bay doors. Those items, toilet, bay door, water heater, to the extent that the water heater still works, those are really maintenance type things that need to be dealt with. Also, what the court doesn't have before it, and I understand that this is taking place before discovery, and probably would be wise for the parties to do that. Sometimes discovery is not indeed ordered in these cases, and typically not in my summary proceedings actions. But where a motion has come forward, something can come forward to the court to indicate that there is at least a colorable defense to withholding rent. I don't find that in this case. I think that the testing of the drinking water, had the tenant thought that that really an issue, could have said something initially upon moving into the premises, but also could have proceeded along the lines of having the county come and check the water. Quite frankly, I don't know that the county found that the water could not be consumed, or in some way pose some other danger, I doubt that anyone would be able to occupy those premises for either commercial or residential purposes. The electrical panel, to the other issue. Landlord came in and did some things, certainly, as council has indicated, probably for the preservation of the property. But I don't have anything that says that electrical panel needs to be changed out. I also think that the defendant should have made some effort to have an electrician brought in, to have something other than somebody told me that this panel is bad. Not even for the purposes of litigation, but for the purposes of presenting it to the landlord to say, look, this panel is no good, it causes a certain hazard. And then at that point, if the landlord doesn't do something, take his remedies. Or, as I had suggested, and has happened in these cases, the tenant, if it poses such a danger, they have a significant basis upon which to do so, make the repairs, and then deduct it from the rent. But that's not what was done in this case. Just all rent was withheld to maybe apparently try to get the landlord to do something. I also don't see anything, while a furnace may go in and out, I am not of the, without more as to why that's occurring. I can't say that is going to create such a defect in the premises to do that. The very age of the furnace, quite frankly, from this court standpoint, doesn't mean a great deal, because furnaces can go for quite a long time. But again, had someone come in, or if it had gotten to the point where the HVAC wasn't working, and the tenant decided to take some of the rental money, make those repairs, or at least tell the landlord this is what I was doing, and it was a partial takeout of the amount, that might have been reasonable. But what has occurred in terms of the not paying rent under this triple net lease, as the language is contained in it, those actions are not reasonable by any stretch of the imagination. I don't see anything that would lead this court to believe that there is indeed any material fact left, or any issue for this court to decide. That there is no genuine issue of dispute in this case, and so therefore will grant the motion for summary disposition of this matter. With reference to and I will do that I'll do that under both C8 and C10, but I don't think that any correction of the pleadings with reference to the C8 motion would lead to any different result. And so I will not provide that opportunity. With reference to the amount of damages, believe that there was with cost and without the deduction for the escrow, plaintiff was at, I think, the 1,000. $113,946.22. That is the amount inclusive of costs that the plaintiff had. While not entirely, well, and I think there would need to be, presumably at least a proration. There was obviously a building dispute as between these parties. The landlord, in this court's mind, certainly could have acted earlier. And had the landlord acted earlier and all of this information had come before the court, many of those late fees wouldn't have veneered in this case, or at least would not have rested then with the defendant if he were and the company were going to have to pay. So what I'm going to do is I'm going to take the 113,946.22, which is inclusive cost. I will deduct from that a total amount of $2,500, which I would attribute to the landlord having, he could have acted, that would mean that he would have just acted half as early, and then we wouldn't be in this boat. I think that that will be a fair result in terms of this action. So that would be the judgment of the court. The way the judgment would have to be prepared is for that full amount as it comes out. Do not deduct that on the redemption line. And then under paragraph, if you're using just standard scale form, under paragraph 10, you would just indicate that the $28,050 will be credited against the redemption amount.
And, Your Honor, I have an order prepared. I need to put in the numbers that you just mentioned, but it'll only take a few seconds.
And in terms of a date, well, in terms of when that needs to be paid by counsel, has asked for some time in that regard. And you had indicated your client needed 45 to 60 days to come up with that. What is plaintiff's position on that? Understanding that it's a statutory 10-day period, however, court does have some discretion, and Mr. Gurney knows that I could order the 10 days, but then he could file motions in this court to reconsider, and nothing happens. So,
I would have to ask my clients, Your Honor. I don't know their position with regard to potentially extending beyond 10.
I mean, I don't mind stepping off, letting you have the conversation, because I think it's going to be important in terms of trying to come up with the funding. I would be the majority of your, hang on one second, the majority of your business is at lawn care.
Yes.
So I'll just tell you this to try to help with this discussion. I'm more inclined to give the 45-day period because part of this has been paid, and also understanding that if the defendant wants to say, I don't want to see a disruption to his business as it's kind of coming into season. So that's where the court is. So.
Your Honor, if this would be acceptable to the defendant and my clients too, because I don't know for sure what they would agree to, we can agree to the end of April, which is very close to the proposed amount of time, provided that we are paid April rent, and that acceptance of that rent would not be, a waiver of the possession judgment. So, but we'd want that just to come to my office. Would that be acceptable? That April rent would come to my office? Yeah, there's a whole because I mean, it's like overseas. That is it.
How old is the person?
So it might be, you're counting days, so I didn't want to interrupt you.
No, it's okay. Funny, you knew what I was doing. Go ahead.
I could tell. I don't know how close that gets us to 45 days. Again, we would ask for the 45 days to be able to do that. I don't think there's any problem in paying the April rent in Mr. Troika's office. I don't think that that's an issue as opposed to paying into the escrow indefinitely, right? I think the escrow would be released. We would pay the April rent when it is due into Mr. Troika's office so he could distribute that to his clients. And then by the 45 days from now, be able to pay up the remaining amount, which I believe I've got a lot of papers on my desk, but is, I won't say to put me out of my, but 81,623.92.
Well, let me do it this way, and this may seem a little bit complicated, but again, I'm trying to take into account, make sure they get their funds as soon as possible, but also realizing that the nature of his business is such that it's dead for a while, kind of. I mean, you got the snow removal part, but it doesn't all happen in this coming this spring. So, and I do it this way with standard judgment, that if the defendant, say it's 23rd, the 6th, you could get April rent to them before the 6th of April. The day, okay. So what I'm going to do is I'm going to grant I'm basically going to start with 2 weeks. So in paragraph 4A of the standard judgment, it would indicate that a writ would issue April 6th. And then also under paragraph 10, for a further order, that if the defendant pays April rent by April 6th to counsel's office, that the writ date or order of eviction date is extended to the 30th. Well, no, I'm going to extend it to May 1st. Then I will indicate that when do you think you could get May rent to them? Did you get it by the 1st or the? And that if May rent is paid by the 1st, you will have until the 15th of May to pay the balance.
Well, I'm sorry, have until when?
Pay 15th.
What, by the 15th?
Pay the entire balance.
Oh, just to be clear, would they be paying half of May or all of May?
No, they've got to pay all of May. They've got to pay the May rent
Okay.
by May 1st, and that gives them an additional 14 days to make sure that they can come up with the rest of the month.
Okay, and just to be clear, if they don't come up with the rest, then we're getting May, even though they'll be out.
Even though they'll be out,
Okay. That
keep what's there.
makes sense. Yeah, I'm working on an order here. My writing's good, but
I said a lot more, and it's a lot that's going to have to go into paragraph 10. Figure that out for me. The only other thing is, and I almost hate asking this because I think we've got the people up there to do it, but I'll double check. Did you want to check today on the escrow?
we checked last week. I think we agreed it's $28,050. Did you?
Yes.
I didn't check, but I was just trusting that you checked. So.
Want to run one? Did you want one today?
No, we
Sure.
checked the way out, but I mean, your client could tell us that we paid more. We know it's not less.
No, I have it right here in front of me. It's your figure was absolutely correct.
Okay, good.
The only thing I was asking is, did your client want to walk out with the check today, as opposed to waiting for it to come in the mail?
I will be happy to walk out with the check today.
I kind of knew you would say that. But Troy He's pushing back at me, and I'm like, why?
Attorney, if they want money now.
I know. I don't even know why. All right. I don't know if I'm going to be able to accomplish it, but I'm going to check with my staff and see if we can.
Your Honor, we did prepare a separate order. I don't know if you need one. Just
For release of the escrow?
SCA form for that.
You could either do that or it could be on the judgment form, either way.
Okay, I mean, I have it in, I don't think we need it. You know what, Your Honor, just said. Okay.
If he pays nothing, well, here's what it is. Under paragraph 4A,
April 6th.
April 6th, we usually put a little asterisk next to it, and it just says, see paragraph 10. Under paragraph 10, if he pays the April rent by April 6th, redemption date's extended to May 1st. If he pays May 1st rent on that date, then it's extended until the 15th for the entire balance. Yeah, she could just call.
The May 1st.
Yeah,
Going over there.
you're going over there to help him, right? And counsel, thank you both very much. You guys gave court a very good argument, and I always do appreciate that, gentlemen.
Thank you, Your Honor.
It's always strange to be in this courtroom with
As both sides finished presenting their arguments, the courtroom narrowed its focus to one central question. The dispute was no longer just about unpaid rent or maintenance concerns. It became about whether the evidence presented legally justified withholding payment under the lease. Throughout the hearing, the judge repeatedly asked for clear documentation, expert support, and proof that any alleged problems were serious enough to warrant the remedy being sought. While each side maintained its position, the discussion ultimately highlighted a key principle of commercial lease disputes. Allegations alone are not enough. The court must weigh the lease terms, the available evidence, and the legal responsibilities of both landlord and tenant before reaching a decision. The final ruling now depends not on emotion or speculation, but on whether the facts and the law support either party's claims.